At 10:31 in the morning, I watched a defendant make the single most common mistake that destroys white-collar cases. He believed the courtroom was a theater, and that confidence could overpower evidence. That illusion lasted exactly 28 seconds. Let me be precise. This isn't a story about politics. It's a story about federal procedure, about pre-trial release conditions, and about what happens when someone tries to manage a witness the way they manage employees. The defendant, let's call him Grant Holloway, was 46 years old, dressed in a charcoal suit that looked freshly pressed, sitting beside counsel like he belonged there. The indictment said he didn't. 11 counts. Wire fraud, conspiracy, false statements, and an obstruction-related count that, at the time of arraignment, looked like a throw-in. By the time this hearing ended, it looked like the Centerpiece. Grant ran a construction procurement firm that helped small cities win federal grant money for infrastructure projects. On paper, it was legitimate consulting. In reality, prosecutors said it was a funnel, inflated invoices, kickbacks disguised as success fees, and a spreadsheet that tracked which officials got paid, when, and how. He was out on bond pending trial. Strict conditions. No contact with witnesses. No third-party messaging. Surrendered passport. No new financial accounts. The kind of bond package a judge signs when he wants to give someone a chance to show the court they can behave like an adult. Grant treated it like a speed bump. The government had called its morning witness, a former operations manager named Elise Kwon, early 30s. Calm voice. The kind of person juries listen to because she isn't performing. She was also, in the government's words, the keeper of records. She didn't make the policy decisions. She executed them. She built the folders. She maintained the payment logs. She knew where the bodies were buried because she was the one required to label the graves. Direct examination was methodical. Emails, invoice chains, a ledger export, a screenshot of a shared drive folder labeled Q3 closeout. Prosecutors were laying bricks. Then cross-examination began, and defense counsel tried the oldest play in the book, make the witness look petty, confused, and biased. Suggest she's here out of revenge. Suggest she's doing this for immunity. Suggest she's guessing. Guessing. Elise didn't bite. She answered cleanly, yes or no. Date and time. She didn't argue. And then defense counsel asked the question that changed the temperature in the room. Ms. Mass. Kwon, he said, you deleted the spreadsheet, didn't you? This is the moment inexperienced lawyers miss. When a defense attorney asks a witness about destroying a document, there are only two reasons. Either the attorney already knows the witness did it and wants to assign blame, or the attorney is gambling that the witness will say something reckless. Elise didn't say something reckless. She said, I deleted it after I was told to delete it. And she looked, not at the lawyer, but toward the defense table for half a second. The kind of glance that tells you the name she's not saying out loud. Grant didn't react. He leaned back slightly, almost amused, like this was still controllable. Then the prosecutor stood up. Your Honor, she said, may we approach? Sidebars are usually boring. This one wasn't. The judge listened. He nodded once. Then he looked at defense counsel. Counsel, he said, I'm going to allow limited redirect on this issue. Limited redirect. Translation, something just got dangerous for you. The prosecutor turned back to the witness. Ms. Kwon, she said, you said you were told to delete it. Who told you? Elise hesitated, not because she was unsure, because saying it out loud makes it real. Grant Holloway, she said. Grant's jaw tightened just slightly, the first crack in the armor. The prosecutor continued. When did he tell you that? Elise answered. The night before the FBI came to my apartment, around 8:40 p.m. Specific time, not sometime, not that evening. That number matters because prosecutors don't use precise times unless they can corroborate them. And how did he communicate with you? The prosecutor asked. Elise's answer was the one that made the judge's posture change. Through a voice note, she said. On an app he told me to install. He said it didn't keep records. Now, if you've been in federal court long enough, you can see where this is going before it gets there. Do you still have that voice note? The prosecutor asked. Elise said, yes. And you could feel the defense attorney's internal calculation in real time. If she has it, then the government has it. If the government has it, we are no longer in the realm of interpretation. We're in the realm of proof. The prosecutor held up her phone like it was nothing, like it was just another exhibit. Your Honor, she said, the government moves to publish Government Exhibit 72. Defense counsel shot up. Objection, he said. Foundation, authenticity. The prosecutor didn't flinch. We have authentication from the service provider, Your Honor, she said. We have extraction logs. We have the witness's testimony. And we have a matching call detail record showing the defendant initiated contact at 8:42 p.m. The judge looked at defense counsel. Overruled, he said. Play it. And this is where the story becomes simple, because audio doesn't care about legal theory. The courtroom speakers crackled for a second, and then Grant Holloway's voice filled the room. Not angry, not threatening. Worse than that. Casual. Managerial. Like he was giving an employee a task before close of business. Listen, the voice note said. Delete it tonight, not tomorrow, tonight. And don't talk about it. If anyone asks, you don't know what they're talking about. It's just a spreadsheet. Make it disappear. 28 seconds. That was the entire voice note. But in those 28 seconds, you could hear the elements of obstruction line up like iron filings snapping to a magnet. Instruction, timing, concealment, and a plan for a false explanation. Grant didn't move at first. Then he did something tiny and involuntary. He swallowed hard like his throat suddenly went dry. The prosecutor didn't stop there because prosecutors don't stop after the first punch if they know the defendant is already off balance. Your Honor, she said, the government also moves to admit Government Exhibit 73, a screenshot of a follow-up message sent 4 minutes later from the defendant's account stating, quote, no screenshots. Delete after listening. No screenshots. Delete after listening. No screenshots. That phrase is not an accident. It is consciousness of guilt in plain English. Defense counsel tried to recover. Your Honor, this goes beyond the scope. The judge cut him off. It's directly responsive, he said, and it is highly relevant. Then the judge asked the question that ends bond hearings. Counsel, he said to the defense attorney, was your client under a no-contact order with respect to this witness? The defense lawyer paused for a fraction of a second too long. Your Honor, he said, he was instructed not to contact potential witnesses. Yes, not no, not there's a misunderstanding. Just yes. The judge turned to the prosecutor. Is this witness on your witness list? He asked. Yes, Your Honor, she said. Filed and served. The judge nodded once. Then he looked directly at Grant. Mr. Purpley, Holloway, he said, stand up. Grant stood, and for the first time the confidence looked like what it always was, a mask that only works until evidence touches it. Do you understand? The judge asked. The contacting a listed witness is a violation of your release conditions. Grant tried to speak. Your Honor, The judge raised a hand, not dramatically, but decisively. Counsel will speak for you, he said. Defense counsel jumped in fast, because this is the moment you either save your client or you don't. Your Honor, this was not intended to. Not intended. The phrase that dies in the face of an audio recording. The prosecutor stood again. Your Honor, she said, this isn't just a technical violation. This is witness tampering conduct under 18 U.S.C. Sesh. 1512, and destruction or concealment under 18 U.S.C. Section 1519. It goes to the integrity of these proceedings. And here's the legal reality. Judges can forgive mistakes. They can forgive confusion. They can forgive late paperwork. They do not forgive a defendant trying to shape testimony or erase evidence while standing in front of the court under supervision. Because if the court can't protect the process, the court can't function. The judge set his pen down. That sound pen down means he's done taking notes. He's done weighing. Now he's deciding. I find, he said, by clear and convincing evidence that the defendant violated the conditions of release. I further find that no condition or combination of conditions will reasonably assure compliance going forward. Then the sentence that takes the air out of a room, bond is revoked. The defendant is remanded. Grant's face didn't contort into a movie expression. Real panic doesn't look like that. Real panic looks like a person trying to stay still because movement might make it worse. Defense counsel immediately asked for a stay. 48 hours. A surrender date. Anything. The judge shook his head once. Denied. And then the marshals moved. No rush. No drama. Just trained professionals walking forward like they've done it 1,000 times. Because they have. Grant looked at his lawyer as if the lawyer could reverse physics. The cuffs clicked, sharp and metallic. And that sound did what the prosecutor's words couldn't. It made the consequences physical. Here's what most people don't understand about moments like this. The remand isn't just punishment, it's the court protecting the case. Because if a defendant is willing to tell a witness to make it disappear on the eve of an FBI visit, what are they willing to do once trial pressure hits? What are they willing to do when they realize a jury is actually listening? That 28-second voice note did more than revoke bond. It likely added years. Obstruction conduct can trigger sentencing enhancements. It can change plea negotiations. It can turn a manageable exposure into a catastrophic one. And perhaps most importantly, it tells the judge something the judge will never forget at sentencing. This defendant did not respect the court's authority when given the benefit of freedom. The law applies regardless of who you are. And federal judges, in my experience, are patient right up until the moment you prove you're not trustworthy. Grant Holloway proved it on audio. So let me ask you the question that matters. When a defendant on bond tells a witness to delete evidence and avoid screenshots, is immediate remand the only responsible decision? Or do you think a judge should still try stricter conditions first? Leave your thoughts in the comments. I read all of them, and if you want more breakdowns based on procedure evidence and what actually ends cases in federal court, subscribe, like, and share. Because the next time someone says, it's just a technicality, I want you to remember what a technicality sounds like when it's played through courtroom speakers.